There are no disputed issues of material fact, and the movement is entitled to judgment as a matter of law. Looks like I ran over the 3 minutes, but we're almost done, guys. So summary judgment is really, what it really is the judge takes a look at all the evidence from both sides and says, could a reasonable jury find for this party? So if I move for summary judgment and I say I should win, and the other side says, no, you shouldn't win, the judge can look at all the evidence and say, you know, I don't think any jury on earth could find for the defendant. And I think under the law and under all these facts that the person who filed the summary judgment motion is entitled to win. And if that happens, you get summary judgment and the case is over. Now, if there's a disputed issue of fact or if there's a dispute about the law, you will not get summary judgment, and then you will go to trial. Now, before trial, you have various pre-trial motions. The two most common, I'd say, are a motion in limine. A motion in limine is a motion to limit evidence at trial, meaning, you know, if you know the other side is going to try to say some horrible thing about you or bring up some character flaw that you don't think is admissible, you can ask the judge in advance, judge, keep this out. Order them before the trial that they can't even talk about this. It would be too prejudicial. And the last one I mentioned was a Daubert motion, which is a term of art. But a Daubert motion is a motion to exclude expert testimony in the case on the basis that the testimony is not sufficiently based on scientific principles, processes, etc. Essentially, the Daubert motion and the Daubert test keeps out junk science expert opinions. It would prevent a guy from like coming in and giving some crazed opinion that, like, you know, the moon beams can affect your brain in a way that makes you commit murder and it's not your fault. That would probably fail a Daubert test because it's not based on any scientific evidence. So after all that is done, after everything's said and done, all the parties know everything, everybody knows what's going to be said and what can't be said and all that, you go to trial. So the jury, you guys on the jury, you don't really, you think that, like, it looks like it's all new to you. I'll put it this way. The lawyers know what's going to happen. The attorneys know everything. The judge knows everything. Everybody knows what all the evidence says. The judge has already, like, read all the motions, the evidence, and already decided there wasn't enough to rule. But believe me, they understand what's going on in the case. So while if you're ever on a jury, you may think there's, like, you know, these TV moments where, like, some witness storms in out of nowhere and everybody goes, and there's some bombshell, highly unlikely. All the witnesses have already been deposed. Everybody's already gave their statements. Everybody's testified. All the documents are exchanged. If somebody tried to come in on the day of trial with some new piece of evidence they've been sitting on the whole time, it would be excluded. That's the whole point of discovery and all of that. So I hope somebody may have found this informative. I'm happy to do follow-ups, but I mean, looks like I'm going to come in just under 6 minutes, but that is pretty much the civil litigation process in a nutshell from start to finish. I hope somebody finds this helpful. Like and follow for more legal wisdom.